Good morning. My name is Surisha Ganta, and I'm Counsel and Education Director at the Pro Bono Partnership of Atlanta. We are excited to have with us today Jerry Williams and Courtney Tucker, Assistant General Counsel and Corporate Counsel, respectively, at the Home Depot, who are here to speak with us this morning about Contracting 101, some tips for nonprofits as they look to formalize and document their agreements with vendors, partners, and grantees and grantors. But before Jerry and Courtney speak about the substance of today's topic, I want to take this moment to tell you, our audience, a little bit about PBPA. The mission of Pro Bono Partnership of Atlanta is to provide free legal assistance to community-based nonprofits. We are able to do this through the assistance of volunteer attorneys like Courtney and Jerry, who are supported by their organizations, local businesses and law firms of Atlanta. We match them with nonprofit organizations to provide direct legal services and also to provide educational opportunities like today's webcast. To find out more about PBPA and what our client requirements are, you can visit our website. Our clients are small 501c3 nonprofit organizations that tend to be headquartered in the Atlanta metro area or whose services focus on the Atlanta metro area. Our clients all serve low income or disadvantaged individuals, and the organizations are otherwise unable to afford legal services. If you're interested in applying to be a client, please go to our website and complete a request for legal assistance. Also on our website, you'll find a wealth of resources, including articles, past webcasts, and podcasts. And in the future, we hope to be able to provide in-person workshops again too. Now, a quick disclaimer about today's presentation. Please keep in mind that this is all just general information. It is not specific legal counsel. If you have specific questions about your organization, please reach out to an attorney. During today's presentation, Courtney and Jerry will be able to take some questions from our audience members, but please keep in mind that their answers will remain general and will not count as legal counsel. And today's presentation is also copywritten. So now I will turn the mic and the camera over to Jerry and Courtney.
Hi, good morning, everyone. Thank you so much for joining us today. So as Sharisha shared, we want to give you some tips and tricks on how to be successful at your contracting in your day-to-day operations. So what we'll do is go through quickly what a contract is. We'll talk about the purpose and benefits of contracts, the common types of contracts that you may see in your operations, legal requirements of contracts, key terms of contracts, and then we'll kind of close things out with some contracting do's and don'ts, and then open it up for any other questions folks have. We want today to be as interactive as possible. Please feel free to chat your questions as they come up, and Jerry and I will do our best to answer them as they come through the chat. Next slide. Oh, sorry, go ahead, Jerry.
Yeah, so good morning, everyone. Many people are intimidated by contracts, and I want you to know, fear not. We enter into a variety of contracts in everyday life. So when we go and get our oil changes, right? When we get the oil changed on our cars, when we contract for lawn service, pest control service. And this morning I entered into a contract with McDonald's, if you can see my large cup of coffee. It's a very simple type of contract. Those are examples of simple types of contracts that we enter into every day. Today, we're going to drill down, and as Courtney said, we're going to give you some tips of the trade to make contracting less intimidating for you.
Thanks, Jerry. So as Jerry mentioned, what is a contract? We enter into contracts daily. When you drive up to McDonald's menu and there's a price there, you order based on that price and you pay at the window. You've entered into a contract. At its simplest form, a contract is an agreement between two parties, between you and McDonald's there that morning at the drive-through. A contract can be either written or oral. in some contracts must be written to be legally enforceable. When you ask, okay, so what contracts do you have to be in writing? We're thinking about contracts that are for real estate, contracts that are for products that are over $500, those types of contracts, and any contract that's going to be for more than 1 year. Courtney, why do those contracts need to be in writing? Because you want the oral contracts are very difficult to prove. If you have to litigate or go to court over a contract that is oral, it becomes a he said, she said. So you want to make sure that you get your important contracts in writing so that it's not one person saying, yes, we agreed to this, and the other person saying, no, I thought we were agreeing to something different. If it's in writing, then you don't have those qualms. A well-written contract should have both parties' rights and the obligations and define how the disputes will be resolved. And we're going to go further and deeper into what types of terms and definitions need to be in contracts, but we'll make sure we talk through that as well. So then the next question is, what is the main purpose of a contract? The main purpose is to memorialize the who, what, when, where, and the cost of what you're purchasing or agreeing to contract about. This is very important. You want to make sure that all of your key terms are addressed in the contracts. And this helps us to minimize confusion during kind of the if there becomes a legal dispute. You know, the thing is like, when you go into these contracts with your different vendors or your suppliers or whomever, you don't think that you're not contracting because you think there's going to be a dispute. You contract in case there is a dispute. And so you just want to make sure you're documenting each of the terms that you find that are important or that are important to that contract. So when we think about the types of contracts that are important and that you may come across in your day-to-day operations, we'll say, let's just start off with purchase contracts, service agreements, the bill of sale for purchases of goods, maintenance agreements for your daily operations, for your HVAC in your buildings, if that's a part of your operation, for your janitorial cleaning staff, if they're coming into your operations, and real estate, a real estate sale agreement. It could be if you're purchasing the building for your operations, and or sometimes consider leases if you're leasing space for your office space for your operations. Sometimes we lease equipment such as copiers. Some folks lease computers. You want to make sure that the number of computers or copiers that you're leasing is in the document. You want to make sure that the cost associated with that lease is in the document. You also want to make sure that if there is any type of repair services associated with that lease, that's included in that document. Also consider agreements for software license agreements. These are your customer retention products that you use to maintain your customer database or your Microsoft Office. Those types of software agreements are important to make sure you keep and make sure you know the cost and know when you have to renew those agreements. Other types of agreements that you want to consider are employment contracts. How long someone's going to work for you under maybe a consulting agreement. Confidentiality agreements are very important. Your secret sauce of how you're running your business is important to you and your operations, and you don't want other folks going out and sharing that information. So confidentiality agreements will help you protect that information so that when you share with a consultant or an independent contractor how it is that you do certain things in your business, they're not able to go out and share that with another nonprofit if you deem you don't want that shared. Finally, I'll share business contracts. Business contracts will be around your sponsorship agreements, media release agreements, liability waivers. If folks are coming in on your property and you're taking photos, you want to make sure that they've given you the ability to take those photos, or even something like today when you're doing video conferencing and you're going to share it publicly, you want to make sure people are in agreement that their photo or their likeness is okay to be shared. Anything you want to add to this one, Jerry? Okay. I see someone says they can't see the slides.
Courtney, I have a question for
Sure.
you. Going back to the list of what the types of contracts. Is an MOU a contract?
That's a tough one, Shrisha. It is in writing. It is a memorandum. A MOU is a memorandum of understanding. It is in writing, but I would I would, Jerry,
So,
I'll let you.
right, so a memorandum of understanding is in fact a contract. Most memorandums of understanding contain a number of conditions, including the fact that you have to agree to some additional terms and conditions. So a memorandum of understanding is in fact a type of contract, but be careful about the contents because it may not be a strict contract. It's an agreement to agree later. It's an agreement. It represents a letter of intent, the party's intention of moving forward with negotiations. So it is a type of conditional contract.
Thank you.
You're welcome. The only thing I would add, and I think Sharish, Jerry alluded to it, is with the MOU, you always want to make sure you follow it with a contract because the courts can sometimes see that MOUs are non-binding. And so that's the only part I'd share. The next part is when we think about the legal requirements of contracts. So Courtney, you told me what a contract is. You told me when I need to use a contract. So Courtney, what is legally required for me to have an actual contract? So I'll tell you, the first thing you need to have two people over the age of 18 that want a contract. They have to be valid, either natural people or legal entities. So it can either be you and your partner, if you guys decide you want to do some type of partnership agreement, or it needs to be you and an LLC, or you and a corporation or another nonprofit. I will say it's often important to, if you are going to contract, we typically recommend that you try to contract with a legal entity because they do typically have the insurance requirements and have followed the steps that the state required to be a legal entity, and will sometimes offer you additional protections than just contracting with a legal person may. Next, after you have those two people, do you have to have an offer? Courtney, what's an offer? It's a party's expression of its willingness to be bound by a contract with the other party specified by the terms and the conditions. So it's, hey, me coming and saying, hey, Jerry, would you like to buy my car for $500? I am offering Jerry a car for $500, and I am expressing that to her that I'm expressing to her that I would like her to buy my car. Acceptance is the next element of this process, and it's the party's unconditional agreement to the terms of the offer. And so if Jerry in turn comes back to me and says, Courtney, yes, I would like to buy your car for $500, Jerry has then in turn accepted the offer that I have I've given her. The next element of this is consideration. Consideration is the exchange or value of the agreement. When I say, Jerry, would you like to buy the car for $500? And Jerry says, yes, Courtney, I would like to buy the car for $500. The $500 is that consideration. So when Jerry gives Courtney the $500, we then have consideration for the contract. In a contract, there must be also a meeting of the minds. And sometimes you won't necessarily see this in writing, but that meeting of the minds is important because it shows that both parties are agreeing to contract for the same thing. So Courtney just said, Jerry, would you like to buy my car for $500? What if Courtney had two cars? What if Courtney has a Toyota and a Mercedes, and Jerry thought that Courtney was selling the Mercedes for $500, and that's what Jerry agreed to buy for the $500. In that situation, there may not have been a meeting of the minds, but that also is a reason why we want to make sure that our contracts are more detailed. So Courtney should have said, Jerry, I'd like to sell you my Toyota for $500. That way, when Jerry accepted my offer for $500, she knew what vehicle she was purchasing. So meeting of the minds is really important. And I think oftentimes that's when you'll find, like, a lot of the contract disputes that we see is there was a miss in that meeting of the minds. And then I realized the slide is cutting off a little bit at the bottom, but what's missing from the only thing I'll add is in a contract, you want to see your T's and C's, your terms and conditions. So in addition to the vehicle, what type of vehicle, what else is Courtney offering for this $500? Is she offering any oil changes, future oil changes with this car? Is she going to give additional tires? Does she have seat covers? those types of things. Are there any other terms that are associated with this contract? And we also always want to make sure that those details are filled in. Thank you. Next slide. So we talked about terms and conditions. So let's talk about the key terms of a contract. We talked about parties. The parties must be a natural person or legal entity entering into the contract. And when we say legal entity, we mean, of course, your LLCs, your other nonprofits. They can definitely be corporations or partnerships. Term of the contract, the duration of the contract is very important. How long do you want to contract with your service provider, with your maintenance provider, with your lease? How long do you want to stay in that space? We want to make sure you always say, hey, what is the start date of this agreement? What is the end date of this agreement? When does this contract end? By what day do I have to be out of this space, or do I have to return the computer or the copier? Or what day do I need to come back and tell this maintenance provider or the janitorial staff that I'd like to restart the service? Oftentimes in your contracts, you'll see that there is an auto renewal in contracts. And the typical language will say, at the end of this contract will auto renew for a period of 1 year, every year at the anniversary date. This is okay, but make sure that you're aware that the contract does auto renew, because it does create additional financial obligation on you and your organization. It's very important that you monitor that. Maybe you have a personnel or person on your staff that can monitor it. I always do calendar ticklers to say a year from now, hey, 30 days from now, this contract renews. Do we want to renew it? Or do we need to tell the service provider, thanks, but no thanks, we found someone else, or we're going to do it ourselves? It's just very important that we make sure that we're communicating before the next renewal date of those contracts. Oftentimes, you'll find that there are different obligations that come with that renewal date. Prices could increase that day, could increase at that time, or they could just renew for another year, and you may not want to do that. Another term that's important in the contract is the termination. Termination rights in a contract are really important. This is how you end a contract. Termination could be for any reason. You're no longer happy with the services. Termination is, hey, I found a new vendor that is going to offer me the services better, or a lesser cost, or I'm closing down operations and I just need to terminate the contract. Termination rights are typically because you want to end the contract early, and oftentimes you'll find there are different obligations associated with the termination rights. Best contract you could ever get is if you could terminate it with no obligations. You could just say, hey, done with the contract, don't want to do business with you anymore. But oftentimes that's not the case. There's typically some type of obligation where you may either you may have to pay for the remainder of the services in that contract, the remaining value of that contract. So there's some type of obligations. The way you can typically protect, there are many ways you can protect yourself around the termination rights in a contract. You can contract for a shorter period of time. So if you typically contract for 3 years, you don't know if you want to contract for that period, you can try to contract for maybe 1 year, or contract for 6 months. But that will limit the potential financial obligation if you decide you want to terminate for a shorter period of time. But other reasons you may need to do early termination is for cause or breach. If you're engaged with the supplier and they are just not meeting your needs. If you hired a janitorial staff and you said that you need them to clean, the bathrooms and the kitchen area, daily, based on the standards of the organization, and they're not meeting those needs, and you need to go somewhere else, you want to have the right to get out of that contract. So some more key terms and conditions of a contract are deliverables. Key deliverables need to be defined in your contract. If you are engaging with a consultancy and they are doing some type of work for you, you want to define what those deliverables are. Are they supposed to offer you a presentation or sales a fundraising presentation to you by a certain date? You want to define what the presentation is. You want to define when, by what time, and by what day they offer or need to offer you that presentation. And then what happens after you get the presentation? Is there an opportunity to do drafts? Are there other things that you want to review? Or do you want to have a time to review and give feedback? You want to make sure you have the deliverables and what your expectation is in that contract. That way, by having that, there is nothing left to question on what your expectation is from that particular consulting or whomever the vendor may be. The next piece is warranties. Warranties are important. I think sometimes we gloss over warranties because you just kind of don't think about it. You buy the computer you're on today, you bought a computer, and what if this computer stopped working the day after you purchased it? And normally you can kind of take it back to the store, but if you're working in your nonprofit, you want to be able to have someone you can tug on and say, hey, I bought this computer, it's no longer working. Are you going to repair it? Or are you going to replace it? We need to put those in our contracts as well. This goes for your copy machines if you're purchasing or if you're leasing them. This goes for your software, especially. Is it working in the way that you expected it to work or the way that the vendor put itself out there to work? If it is not, then you want to be able to have someone to say, hey, you said it would work this way. Here, I want to pull on the warranty, so I need this fixed so that it can work and support the needs of our operations. So warranties are very important. Compliance with law. Sorry. Thank you. Yep. Compliance with law is just the other party's agreement to meet the laws of the state, or the federal or federal laws where you are. If you have a contractor coming in to put up lights or build new desk in your space or doing any type of plumbing, if there are any types of like certifications or anything they need to file with the city in order to do the in order to do the work. I'm sorry, somebody's still saying they're not able to see the slides. I'm not sure how we can help them.
I'll reach out to them.
Okay, thank you. If there are any permits or anything that need to be pulled in order to do that contracting work, we want to make sure that they do it. We don't want to be in a situation where they've come in and not pulled those particular permits or not done the due diligence or work that they needed to do before they offer the service, and we're in trouble for that work. So it's very important that we have this compliance with laws term. Confidentiality, I think I alluded to that earlier, but whenever you're engaging with another party, your discussions with that other party, I suggest that you want to keep that information confidential. If you want to keep that information confidential, the information in the contract, the pricing in the contract, any information that you share with a consultant around, what you want for your nonprofit, how you want to build up the nonprofit, or how the nonprofit is run, who you're engaging with, who's helping you in the background. If you want to keep that information confidential, you want to make sure that that's in the contract. All other things that you want to make sure you do is, number one, say it's confidential. Mark your documents that they're confidential. Put them in a file, in a file cabinet to make sure that others can't walk by and just see them in the building, can't see them on your desk. Make sure you protect them, but also you want to make sure that this information is protected in your contracts. So you see a confidentiality clause in your contracts. Indemnification. This is an important term in your contracts because it's a party's agreement to pay for another party's loss or liability incurred as a result of a third party claim. Examples is overspray and property damage or personal injury in a parking lot. You have a building for your nonprofit and a person comes in and visits the property, and as a result of faulty sidewalk that you don't upkeep, a person falls. Whose responsibility is it? Is it the landlord's responsibility or is it your responsibility? If you have a proper indemnification clause in the contract, it could potentially protect you from that type of obligation. So read your leases, read your sales agreement, who's responsible for example, the upkeep of the outside or the sidewalk or the parking lots, and make sure that you're protected from other litigation that could come from any type of harm for people that could potentially be hurting your parking lot. Additional key terms of the contract that we want to make sure we're aware of, and I'll just kind of highlight these. Insurance, require your vendors to have insurance. Insurance is important. You're going to want to reach out to your insurance agent and make sure that you carry the right insurance, but also talk to your insurance agent and say, hey, I'm doing business with this, this entity. Is there any insurance that they need to be aware of that they should be carrying? Is it professional liability insurance? Is it auto insurance? Is it general liability insurance? Make sure that your vendors are carrying the correct type of insurance and that you're getting confirmation that they have the insurance. This is typically done via insurance certificate. Limitation of liability, it's when a vendor or service provider limits the legal liability under the contract. Example is if you have a software provider and their software goes down and it stops you from being able to fundraise for that particular well, that might not be the best example, sorry. If you have a, if you're doing a fundraiser and you're not able to fundraise and you're not able to collect the dollars that you were planning to collect, they want to limit their liability under the contract. Jerry, will you help me with that one? I'm sorry.
Right, so I can think of an example. Someone comes on site, construction company comes on site, they're obligated to help you with an extension or remodel on the back of the building. There's a time period by which it needs to be completed. They say their limit of liability is $5,000, some arbitrary number. They don't deliver, they don't produce. You go out into the market and now it's 3 times the cost to get somebody else to do the work, but the vendor has the ability to walk away and the maximum amount of money they would owe you would be $5,000. So we need to be very careful. Vendors will often say their liability is capped at the value of the services they provide, right? But they could cause a lot more damage while on site. So be very careful about limitation of liability.
Awesome, thank you for that example. Waiver is when a party gives up the legal right they have to enforce a contract. Force majeure is a provision that excuses a party's performance under a contract because of the events that are outside of the control of the party, of the party's control. Examples are COVID-19, blizzards, natural disasters, war, strikes, etc. I think until the pandemic, force majeure was definitely one that a lot of folks kind of just glazed over and breezed by when we saw them in contracts. And now with the pandemic starting in 2020, we see how important it is to have these force majeure clauses. They potentially could protect you, but they also sometimes can protect your vendor from having to perform or provide the goods or services that you expected them to provide. So read these clauses very closely. Look at what they're saying. If there is a force majeure clause in a contract that's given to you, please review it. Make sure that it does not stop them from having to perform your particular contract. It is just really important that we look at these clauses much closer than we potentially have in the past. Finally, assignment on this particular slide. Assignment is when a party transfers the rights of a contract to another party. You've contracted with Microsoft to buy Microsoft Word, and you know that Microsoft Word and PowerPoint is how you communicate with your members. And Microsoft all of a sudden comes back and says, you know what, we've actually sold our business to ABC Word document, and ABC Word document is now who you'll be doing business with. Is this acceptable? Is this something that you're okay with? what if ABC Word document doesn't provide the same benefits that Microsoft Word does? You want to make sure that you know who you're contracting with, and if they decide that they're going to assign this contract to someone else, you have the ability to get out of that contract. So review your contract, know what your rights are under assignment, and just be prepared if there is some type of assignment to assess what the new company's ability is to meet your needs, and you make a decision on if you want to maintain that relationship with that new organization. So at a high level, that's all of our contracting terms and conditions. Now that we've gone through that, let's go through some contracting do's and don'ts. And hopefully this summary won't be inclusive of everything, but it'll get you down the right direction once you start reviewing some future contracts. So first is your vendor due diligence. So do vendor due diligence before contracting. Always, always, always look at who you're contracting with. Do a Google search. Look and see if this vendor has been in the news. Like, is there anything that you need to make sure you know about this vendor before you agree to contract with them? Look at if it's an individual, see if there's anything if there's anything in the Better Business Bureau about this individual. Just do your due diligence before you actually get into the contract with the entity or the individual. The next is get everything your vendor or supplier is promising in writing. We talked about oral contracts earlier, and remember I mentioned if it's over a certain dollar amount, if it's for longer than a certain term, you want to get it in writing. But if I'm honest with you, you want to get anything someone else is promising you for whatever value that you're going to pay in writing, because you don't want to come to the end of that agreement and not have what you thought you were going to walk out with. Jerry gave the great example around the construction. If your expectation is that a sign was going to be hung, on the front of the building and at the sidewalk, and they've only done one or the other, if you don't have it in writing, it's going to be really tough to get them to do that if it's not in writing. The other thing is keep contracts simple. Oftentimes I think that, we see very long contracts and we think that, if we put all of this in and make it super complex, it's going to protect us more. We find oftentimes that, courts are looking at contracts and reading in them for the words that they have on the paper. And we want to make sure that we keep everything simple when you're documenting the contract. Get the vendor's name right. There are so many vendors out there that have very similar names. The difference could be an S at the end or apostrophe, or they could spell it word in a different way. They could say W-E-R-D instead of W-O-R-D. Let's just make sure you get your vendor's name right, because if there is a potential dispute, you want to make sure that the vendor's name is who you're going after, is who you think you're going after. The next thing is make sure the essential terms are in the contract. The simplest things that you want to, the simplest parts that you want to make sure they are is the value, is the cost of the contract there. Make sure the dollar amount that you want to contract for is in the contract. How long do you want to contract? Get these very essential key terms, the name of it, how long, is there renewal options? Is there going to be a price increase at the renewal? You want to make sure that that information is there in the contract. I'll say this to you, and I know oftentimes folks don't do this, but you want to read every word in every page of that contract, even if you're not a lawyer. Oftentimes, like I said, these contracts are going to be written in kind of the simplest way. You're not going to see, you're notwithstanding and whereas like you used to in contracts. So read every word of the contract. Make sure number one, what's there is what you expect to be there. And if there's something that's there that you don't understand, you question it. The person that you're contracting with or who wrote that contract should be able to explain to you what that means in that line. And you have the right to do that in your contract. The next two is allocate enough time for the contracting process. I think sometimes we underestimate how much time it takes to negotiate pricing or what we want in a contract, whether it be with one individual or with a company. Give yourself enough time. If you know your project needs to start on September 1st, give yourself 60 days before that to make sure that you have time to get the contract negotiated before your project needs to start. Next is, do you obtain the required authority and reviews and approvals? Each of your organization has a hierarchy and a signatory that's delegated to sign your contracts. Make sure that that is done properly. You never want to have someone who's not authorized to sign a contract, because I'll tell you, many of your suppliers will say, even though that person was not supposed to sign that contract, we still see you as obligated. No, there can be the dispute there, but you want to make sure that you're having the proper folks review and approve and sign these contracts before you're going back to your vendors. The next is, do you keep a complete legible copy of the contract? We talked about, contract renewals or what happens at the end of the contract, but you may contract today, and then a year from now or 2 years from now, when it's time for that contract to end, you may not remember what you initially contracted for, or what was or what the actual expiration date is. Try to keep a file. These days we get PDFs of contracts. You can get paper copy of contracts. Keep a file and file away a legible copy of the contract, so that if you need to go back and look and say, hey, what did I contract for? Did I get what I contracted for? Did I get the benefit of my bargain? You have something to read and reference. And like I said, you can keep an electronic copy or a paper copy. People probably don't keep as many paper copies these days, but yes. Next is, document all the changes to the contract and amendment. So oftentimes you'll find that you contract and you've been in contract for a year and realize, hey, our operations is growing. I need a bit more services. If you are going to make a change to the contract, you do want to make sure you document that change. I'm sure oftentimes, you get into the relationship with the vendor, you have a great relationship, and you just pick up the phone and say, hey, I need this change. But if you tell them, hey, I need this change, and they say, okay, happy to make this change for you, nonprofit, but it's going to be additional cost, you want to get that in writing. You want to amend your contract for that additional or new service that you're adding to your contract. Thank you. Next slide. Okay, so we talked about all the do's. Now let's talk about some contracting don'ts. This may be a plug for all the lawyers in the room, but hey, don't be afraid to lawyer up. If you get into a contract negotiation, a contract dispute, or something is going on with a contract that you feel like it's outside of what you're comfortable with addressing, you don't be afraid to contact a lawyer. Oftentimes you can reach out to a lawyer it's a quick Google search, or I'm sure your organization maybe, or you can reach out to the this pro bono group and say, hey, I need a reference to an attorney because I'm in this type of contract dispute. You can reach out, get that help. Don't try to navigate these things alone, because sometimes you can do yourself more disservice than benefit for it in the effort of not trying to spend money. So you want to make sure you get the help you need. Next, I'll say is, don't forget important dates. We talked about termination date. The expiration date of a contract. You want to know your start date of your contract. You want to know the end date of your contract. We talked about milestones for deliverables. Don't forget the days that are important to you. If you need a project to start and end on a certain day, you want to make sure that that is documented in your agreement. The next is, don't prepay for services. And this is something, we learn in our lives in just kind of your everyday. If you are doing any type of construction, or if somebody's doing consulting services or any type of service for you, you want to see what the services that they delivered. Now, I'm not saying don't pay deposits. So because sometimes contractors, need money for supplies or something like that before getting started, but you want to make sure your service is complete before you pay your final bill. And so I would say don't prepay for services. And if they're asking for some type of money up front, make sure you document what it is, how much it is, and then what the payment cadence needs to be going forward, so that you guys are aligned on what that payment or that prepayment was for. The next don't sign a contract with blanks. Without the blanks filled in. We all have seen kind of those pre-forms and they just have blanks. And, we'll go in and put our name and our address and, how many square feet, for construction, how many square feet the space is. If there's a blank in that contract, you fill it in, you fill something in. And if you don't know what to fill in, or if you feel like it's not applicable, write not applicable in that space. You don't want someone to take that paper behind you and fill something else in that may cause you additional costs or additional obligations. The next don't agree to terms that you cannot fulfill, that you don't understand, or violate the law or your agency's policies. Oftentimes, like I said, these contracts there could be those pre-written contracts that have a lot of information in them. Read them. We talked about reading contracts, read them and make sure you understand them. And if there's anything there that your organization can't do, won't do, or is not allowed to do, don't sign it. And bring it up to the person that you're contracting with and say, hey, this is just something that we can't do. I need this contract revised to have this removed. And if you don't understand it, hey, you're saying this, what is it that you exactly mean? What is your expectation here? Make sure you understand what it is that you're signing. And then finally, don't overlook the possibility of dispute. I say we all contract in the hopes that we never have a dispute, but really the contract is there in case that there is a dispute. If you have everything in writing, and all of the expectations are there on paper, then you don't have to worry about I should take that back. It's not that you don't have to worry about it. If you have everything in writing, when there is a potential dispute, you have something to point to. You have, hey, this was the term that I expected. This is what I received. And then you can discuss it. So those are all of our contract don'ts. I think we can open the floor for questions.
Thank you so much, Courtney, for this, all this information so far. We did have some questions that came in with pre-registration that I want to present to you. And I think you did kind of address this first one as one of your contract dues, but after you sign an agreement, how do we incorporate new changes into a contract?
Absolutely. So if there is a contract that's already signed and you need to make any changes to the contract, that's simply done through an amendment process. And typically it's a much shorter contract. It can be like a one-page document that states what the changes are and what the cost is for that change. But those typically can be done fairly simply.
And should those be signed by both parties?
Yes, both parties will need to sign it. And we talked about signatory authority. The person in your nonprofit who has the ability to obligate the organization should sign that one as well.
And we often have clients who have government contracts where they have to they get money from the government to fulfill certain services. Do you have any special tips related to government contracts? And before you even answer that, I will make a plug for a whole other webcast we have on this specific topic, which I'll include in the chat.
I don't have any specifically. Jared, do you have anyone to call out?
I will just mention that government contracts are strict. Strict compliance is very important. And to the extent you're contracting with the government, it may make sense to get a consultant to assist with government contracting because the implications can be very significant. So there's a lot of regulations referred to in those contracts. And so you want to have a consultant or somebody who can help you navigate and really appreciate what those provisions mean. But it is a very, very technical, very specific type of contract that you should not stumble through.
Thank you. And we did have an audience member make a good note that make sure every page of a contract is numbered and initialed. Do you guys have any thoughts on that? Because I've seen situations where you have, a contract that's 50 plus pages, and initialing all that is a lot to initial. Do you have any thoughts on the practice of numbering and initialing long contracts or short contracts even?
I think numbering a contract is always really important. I think the initialing is a personal preference. If that makes you comfortable with initially in the contract to show that you've read and reviewed that particular page. I think that is definitely a good practice, but that it's not a contracting requirement.
And one other question we had with pre-registration I'll address is, our organization plans to buy the property of another organization. Do we need to have that in writing?
I think you'll remember that I mentioned there are certain contracts that have to be in writing. Real property contracts for the buy and sell of real property have to be in writing. And
we do have an audience member who's asking to speak further on indemnification. Jody, did you have specific questions about indemnification there, or Courtney, Jerry, was there anything else you wanted to add about the importance of an indemnification?
All right, so I'll speak to it. So indemnification is really important for protecting you against third-party claims. Courtney gave some good examples, and these were actual real examples. So we actually had a consultant come on site, and in the process of arriving to our building, the consultant actually hit a car in the parking lot and also unfortunately hit a person. And because we had an indemnification clause in the contract, we were able to go after the consultant who was there for something completely different, right? They were coming into the office to provide a service, but before they could get inside, these things happened on our property. If we didn't have that indemnification provision in our contract, we would have been, those third parties would have come to us and asked us to fix the car and to handle all of the medical costs associated with the injury that they incurred on our property. By having that indemnity, we were able to go back after that vendor for this loss that we incurred through the accident that happened in our parking lot. You know, the other example is overspray, hiring somebody to come on site to do a very simple paint job. They painted the building, but they also painted cars in the parking lot, right? So there was 50 plus cars that got paint damage. And so you had a paint service that was $2,000 that resulted in $200,000 worth of damage. Because we had an indemnity, we could force that vendor to fix all of those cars. All of those cars got paint jobs, new paint jobs. If we didn't have that indemnity provision, those 50 people were going to come and knock on the door and expect us to cover that cost. And it would seem unfair if we hired a third party to do a service, competent service. We paid them $2,000, but yet we're writing a check for $200K for all the damage they did when they came on site. So indemnity is very important in protecting your organizations from that harm that could happen to people as a result of people we hire, that you hire to come on site to do a service. So there are all kinds of things can happen when a service provider comes on site to perform a service. Accidents happen, people are negligent, people are sloppy, they run over things with the lawnmower, right? There's overspray, there's accidents that happen in the parking lot. So all things, many things can happen, and that indemnity is there to protect your organization in case third parties are harmed.
That was a great example. Thank you, Jerry. And I don't see any further questions in our chat. So I would just like to take this opportunity to thank you both, Courtney and Jerry. And looks like we had one more comment. Oh, fantastic. It was a nice comment. I'm glad that we were able to help you out, Susie, with this information. And yeah, Jerry, Courtney, thank you so much for sharing your time with us and your expertise with us and all these great examples. It was very helpful. And to our audience members, thank you all for joining, and I hope you found this presentation to be helpful. Everyone have a good day.